Hello, Attorney Masa Sam Foray here of the Foray firm with offices in Houston and Chicago. And I am back once again to talk to you about all things related to family-based immigration. So today's question is about asylum. So folks, one thing that you need to know is on the grand scale of immigration applications that you could submit, asylum falls on the very far end, the hardest end of the scale. This is very limited. It is granted on a very limited basis in very specific circumstances. So you want to make sure that you consult with a trusted immigration attorney if you believe that you are eligible for asylum and if you are seeking asylum. Once you're in the U.S. If you're at the airport or if you're at a border, do your best to reach out. There are attorneys who do, come to those locations to aid individuals. Nevertheless, just know that it is a very, very serious and difficult application in many circumstances. With regards to how you actually logistically seek asylum. So, you have to seek asylum and ask for asylum when you are at a port of entry. And again, that could be either at an airport or it could be at a land border, most specifically the US-Canada border or the US-Mexico border. Once you get there, you actually have to say the words that I would like to seek asylum. You may have seen it in movies. That's literally the way that it has to occur. The only other way to get asylum is for you to seek it within 1 year of entry into the United States. That's the baseline rule. As with many things with immigration, if you've watched my other videos, then you know that there are exceptions to many of the rules. One of the rules that has several exceptions is the rule that you have to seek asylum within 1 year. There are actually 4 main exceptions to this 1 year. Number one, you can show that you've been here for longer than a year, and the reason why you waited is because there have been a change in circumstances that have materially changed your eligibility for asylum. So that could be that you've engaged in activities while you were here in the United States, having arrived more than a year ago, that now would seriously put you at jeopardy if you were returned to your home country. The second would be that you need to show that there are some extraordinary circumstances that prevented you from filing within 1 year of coming to the United States. One common example of an extraordinary circumstance would be that you came to the United States as an unaccompanied minor. If you came as an unaccompanied minor when you were 12 or 13 years old, well then it would be unreasonable for USCIS to expect a 13 or 14-year-old to submit an application on their own behalf. And so that would be one example of an extraordinary circumstance where you could possibly seek asylum if you qualified in other categories after being here for longer than a year. But then you need to show that you filed within a reasonable time frame. So again, using the prior example, if you came here when you were 12 or 13 years old and you did not become an adult, obviously until you were 18, you're not going to be able to wait until you're 21 or 22 years old and then claim the extraordinary circumstances exception. You need to file within a reasonable time frame in order to meet these requirements. And then number 4, another exception would be if you had ineffective assistance of counsel. I'm not here to besmirch or denigrate any of my colleagues. Certainly, I believe that almost all immigration attorneys do their very best to help people achieve their ultimate goals, whether that be a path to green card or a path to citizenship or just a path to a successful visa. Nevertheless, there are a lot of untrained, unqualified individuals who, quite frankly, mess up their clients' cases. So if you are able to really lay out and prove that you had ineffective assistance of counsel, then this could qualify as an exception. You would have to show not that you just had a simple disagreement with your attorney, but specifically that you hired the attorney and that they promised you that they were going to do certain things by certain deadlines, and they simply did not follow up on what it is that you actually paid them to do. So how do I actually logistically seek asylum? So again, there is a form with a letter and a number, and in this particular case, Form I-589 is the application for asylum and withholding of removal, Form I-589. So you're going to want to complete a Form I-589 if you are in need of asylum, even if you are here illegally, even if you were convicted of a crime. But of course, you need to disclose all of your crimes and be aware that, as with applying for a green card or for citizenship, there are some crimes known as aggravated felonies that might prevent you from being able to achieve asylum status. Nevertheless, even if you were convicted of a crime or even if you were here illegally, if you are genuinely in need of asylum, it doesn't hurt you to just go on ahead and apply. Nevertheless, just know that you will be barred from asylum if, for instance, you were found to have persecuted anybody based on religion or ethnicity or race. Okay, so if the immigration officers find out that you are, for instance, a war criminal, and it sounds odd, but there are many people who have been involved in very serious, atrocities in their home countries. I am from Sierra Leone, where we had a civil war that lasted for many years, that much of the world is familiar with. A lot of individuals who were seeking asylum from Sierra Leone, once it was later found that they were involved in, the atrocities that occurred, they were unable to achieve asylum status in the United States. So war criminals, unfortunately, you're not eligible. We will not harbor you here in the United States. Secondly, again, if you have committed some aggravated felonies, and to remind you, aggravated felonies are not necessarily felonies under the state criminal code where you reside. So even if you were convicted, let's say, of a misdemeanor in Chicago under the Illinois state criminal code, it does not necessarily mean that that misdemeanor is not going to be considered an aggravated felony for purposes of immigration. And so you need to look on USCIS's website or consult with a trusted immigration attorney who will let you know whether the crime for which you were convicted would preclude you from being able to achieve asylum. Number 3, if the immigration officer determines that just generally you are a threat to the U.S., and particularly under this administration, this is going to be a serious bar, and it's going to prevent you from being able to get asylum, regardless of the harm that you would face back home, if the immigration official determines that just generally speaking, you are too serious a threat to the United States. And then lastly, if you were previously resettled successfully and safely in another country before you came to the United States, so again, by way of example, let's say you came from Sierra Leone in the early 90s during the war that we had, and you were already resettled in England, or you were already resettled successfully in Germany, you would not have been able to seek asylum subsequently in the United States because you were already safe and resettled successfully in another country that prevented you and protected you from the harm that you were seeking to avoid in Sierra Leone. Shout out to Sierra Leone. So I really hope that this was successful. Again, asylum is very, very difficult and complicated, and if you need assistance, you should absolutely seek the assistance of a trusted immigration professional. I hope that this has been helpful, and I look forward to seeing you next time.